Careful what you post on social media. You might get dragged, or you might wind up in the Supreme Court in a landmark free speech case. Justices heard a case testing free speech at school, in an era when all you need to be a bad apple is a smartphone. In 2017, a student named BL was a freshman on the JV cheer squad at Mahanoy High School in Mahanoy, Pennsylvania. Go Golden Bears. But when sophomore year came around, BL was still stuck on JV. No varsity. BL was pissed. Some other freshman girl jumped past her right to varsity cheer. Not only that, but BL thought her position on the softball team sucked too. Things were a lot. Well, one Saturday, BL and her friend decided to vent on Snapchat. They took a selfie with the two of them, middle fingers in the air. The caption had the makings of a future Supreme Court case. School, softball, cheer, everything. BL posted it to about 250 followers, including one of her teammates who took a screenshot and ran to show it to one of the cheerleading coaches. Well, guess what happened next? Angry coaches, backed up by school administrators, kicked BL off the squad. And guess what happened after that? BL sued, alleging that the coaches and ultimately the public school district violated her right to free expression protected by the First Amendment. And that was the question at the Supreme Court. BL was a minor back then, but today she's known by her real name, Brandi Levy. Doesn't Brandi Levy have a First Amendment right to say cheer? But doesn't the school district have a right to limit student speech at school? Well, yes, and yes. During Vietnam War protests in 1969, the Supreme Court ruled that students don't give up their free speech rights when they walk through the school door. But they also said that schools can limit speech if it's materially disruptive to discipline and running the school. Think about bullying, online and in real life. Definitely something you'd want the school to prevent. And that's where Snapchat comes in. Brandi and her lawyers say she wasn't on school property when she posted. She didn't use school Wi-Fi, and her opinions about school or cheer or everyone are basically none of the school district's business. Mahanoy Area School District and its allies say Brandi violated school and team rules, where she agreed not to tarnish the school's image, to respect teachers and the school, and to avoid vulgar gestures and language. Bottom line, says the school, Brandi would have been kicked off of JV cheer if she had yelled "F*** school" in the hallway, and that snap to 250 friends basically did that. A lower appeals court ruled in Levy's favor, and now it's up to 9 Supreme Court justices to decide. Can public schools reach beyond the school door to limit speech when social media apps spread speech everywhere? The justices might just end up establishing the law's first shitposting doctrine.